The next item on the agenda under old business, the discussion of SEB 2023-025. I've been calling it 2022 all day, haven't I? It's the same case though. SEB 2023-025. This is a request by Dr. Janice Johnston.
At the last meeting, July 9th, an order of business on the agenda was SEB 2023-025 to discuss a motion for 025. We entered into executive session and returned, and at that point allowed permitted representatives of Mr. Rossi and Mr. Moncla to speak for 15 minutes each during the comment session or their representatives. And also on the agenda was a recommendation for further investigation. And at that time, the motion was postponed in order that we might obtain a legal opinion concerning the issue of whether this case was completed and completely heard and closed, because there was a difference of opinion. We have received a letter from the Attorney General's office, and I have a letter from outside legal counsel that has a differing opinion that the case in support of my belief that the case is not closed. So to refresh everyone's memory, the motion for a monitoring team and letter of reprimand was voted on by 2 members of the board on May 7th, 2024. And it clearly states that any effort to resolve this matter with an agreed upon monitoring team expired on July 9th. I quote from the transcript of the motions presented. On the first part of the motion, Mr. Lindsay said, "I'm recommending a letter of reprimand with the understanding that the respective parties will reach an agreement as to a mutually agreeable monitor by the next meeting, which is presently being contemplated in July." And he added later, quote, "And if I may, as a part of that, let the board know that should an agreement not be reached as to a monitor in July, that I will come back with a motion to reconsider and send it to the Attorney General." So that's a little bit of emphasis for all of us to reach an agreeable monitor by July. Mr. Lindsay emphasized that the monitor should be a mutually agreeable monitor and that the agreement be reached by the July 9th meeting of the board. The offer is void ab initio as of July 9th. The offer was not satisfied, and Fulton County is not compliant with the terms of the motion as stated by Mr. Lindsay in May. Since then, there is no agreement on that deal. The minutes reflect these matters need to be referred to the Attorney General with a bill of particulars stating the violations that have occurred. I have here, I do have a chart of the list of violations. Of missing documents from 10 scanners used during the early voting on the election in Fulton County for the 2020 election. These are the red squares are the missing documents. There's a law or a rule attached to each of these missing documents, and it totals up to 346 violations if these documents are not found, if they are missing, if they cannot be provided. And there are other violations, including federal election law violations for double counting of votes. We have not met the obligations of the motion from the hearing of SEB 2023-025. Therefore, this case should be referred to the Attorney General with the instruction to immediately investigate with outside investigators the missing 17,852 ballot images, the 3,125 duplicated recount votes, and the missing documents proving that 10 scanners containing 20,713 votes were legally used at early voting sites during the election as listed in the complaint. Based on the advice of counsel, I believe the Attorney General may be conflicted and should seek advice of conflicts counsel to determine who should represent the state election board in investigating this matter. The Attorney General shall report their findings in 30 days to the state election board. If they are unable or unwilling to conduct this focused investigation, they should report to the state election board immediately, report it to the state election board immediately so that we may hire outside legal counsel and investigators to complete the investigation.
Are you finished?
I'm finished.
Dr. Johnson, at the last meeting, the chair asked that this discussion take place in executive session appropriately because there is a potential litigation involved with this case. This case was heard on May the 7th, 2024, and adjudicated by this board. This board voted 2-1 that a letter of reprimand be sent to Fulton County. The letter was sent to Fulton County. In that letter, when it was sent, I knew that there was no monitoring teams in place and no proposals been made. So I stated in that letter, and that letter is a public record that Fulton County had until August to respond to the monitor. Fulton County, though, did 2 proposals were made in early July to Fulton County. Fulton County considered both those proposals, as did the Secretary of State, and selected a monitor. Secretary of State selected a monitor. This board's failure to act doesn't constitute a violation of that. We also, as you read, Member Lindsay, who made that motion, stated that he may come back and make a motion. He said he may come back. Member Lindsay is no longer a member of this board. This case cannot be reopened by a member on the failing side of that motion. This case can be reopened or could have been reopened by a member on the winning side. But that's not even possible anymore because action's already been taken in that case. The letter of reprimand has already been received by Fulton County. You can't undo that at this point. Action's already been taken. There's also a principle in law that I've been advised of called res judicata. It's double jeopardy for criminal cases. It's res judicata for civil cases where you can't be tried twice for the same thing. Fulton County has been tried. Excuse me. Fulton County has been tried. Fulton County has been heard by this board. This board ruled on that on May the 7th. As I stated earlier, there is potential litigation on this. The Attorney General is the appropriate counsel for this board. This is a government board, the state of Georgia board. The Attorney General is our counsel for this. I haven't been advised by any outside counsel. I have not sought the advice of any outside counsel because the Attorney General represents this board. They represent me. They represent each member of this board. I have not seen any letters from outside counsel. So the chair's position, my position, is that that case has been adjudicated, that Fulton County has met its obligation. The Secretary of State met their part of the obligation. This board's failed to meet its portion of that obligation. But even so, Member Lindsay is not here to introduce that motion, which he said he may. And therefore, I see that case as being over at this point. Member Gazal.
Just
Recognize.
briefly, I would like to add for the record, a citation of authority, OCGA 45-15-14. The Attorney General is invested with complete and exclusive authority and jurisdiction in all matters of law related to state authorities, and no such state authority shall be authorized without the approval of the Attorney General to employ other counsel in any matter whatsoever. The Attorney General is authorized to designate and assign any Attorney General, Deputy Assistant Attorney General, Special Deputy Assistant Attorney General, or attorney to perform legal services for any such state authority.
Let me add one further comment that reopening this case, the attempt to reopen this case sets a horrible precedent for this board. There are hundreds, if not thousands of cases that have been adjudicated by this board to date. If we create that precedent of reopening cases, it's a never ending scenario. So
Question.
Member King.
Thank you. Just for clarity, when was the Fulton County trial?
I'm sorry.
When was the Fulton County trial? You said it's already been tried.
I
The
said
case
the
has
case
already
was
been tried.
adjudicated. The case.
No, you said it was tried in Fulton County.
I don't recall saying it was tried in Fulton County. I said the case was adjudicated.
Okay, so there hasn't been a trial. Do you remember saying anything about the word trial at all a few minutes ago?
I don't recall using the word trial.
Okay, so there was no
I
trial.
said it was tried and adjudicated.
Where was it tried?
Well, this board adjudicated that case.
We tried it?
Yes, on May the 7th.
Okay, because I wasn't here. That's what I'm asking. I'm just
Right.
trying to make sure I
It was on-
understand.
It was during the board meeting on May the 7th.
Okay, so the board tried this case.
The board heard the case, yes,
Okay,
on May the
I'm
7th.
just being clear because you
Yes,
said
yes, the
tried.
board heard the
Okay.
case. The board voted on May the 7th.
Okay, so I've sent emails to, and this is, with respect to y'all being here, I have sent email to the AG's office asking for some specific information in regards to another matter, and I've yet to receive anything back. So are you saying that if we don't hear from our counsel, that we can't seek counsel outside if we have no communication with our counsel?
As an individual, you can talk to anybody you want, but as the board,
Correct.
our
Okay.
legal representation is the Attorney
Okay.
General's office.
So if I, as an individual, because I haven't received any information from those who are supposed to be representing us, if I, as an individual, seek outside counsel just to ensure that I'm doing what I'm proposing to do or is correct, I can do that, correct?
Of course.
Okay. The outside counsel information you received, Dr. Johnston, it's in reference to this because we have very little communication with our counsel, correct?
It's not because of a communication issue. It's because of a concern of perhaps conflict of interest.
Okay, so it's because our attorney also represents the Secretary of State's office,
Correct.
which could pose a challenge when it comes to this particular case, correct?
It may, and so that's an issue. Also, the terminology of reopening the case, we have not closed the case. There have been multiple references over the last 3 months about this case concerning review of the evidence that was not reviewed at the time of its presentation on May 7th. No one has asked me what I found in reviewing Exhibit 11 at great inconvenience to myself. And now that evidence is being held from me to review further. I had asked Fulton County to perhaps be here today to answer further questions, maybe to give an update to for the missing documents. I would like nothing more than to find the missing documents. This is about the data. This is about the documents, that nothing more. It's about the proper counting of votes. And I would love for Fulton County to show me every single thing and say, here are all the votes. We just couldn't find those documents. Here they are. These scanners were used. We're missing ballot images, but we have the ballots, and we'll show you the ballots. It seems to me that somebody is moving heaven and earth to not allow anyone to get to the paper ballots. I don't know why. I'm just interested in the data and interested in the numbers. I'm not interested in who got more votes. And that's not the whole point of this investigation. It's about the proper counting of votes. And so the issue with calling it reopening the case, I don't think that's correct. It's on the state election board determines if and when an investigation is concluded. And in my opinion, it has not been concluded. There are other areas that these documents may be found, such as at the clerk of the court, or such as actually the Secretary of State contains similar documents. I would love to find proof that those 10 tabulators were actually used. And then it would just make that part of the complaint evaporate. Now, the question of double counting of votes, Fulton County admitted that, and that's a serious violation of Georgia law and federal law. And I don't know why that's not even recorded in the letter of reprimand, I don't believe, because what the violations that were used in the letter of reprimand were some vague something about the recount process and had nothing to do with counting, double counting of votes. So in conclusion, I would make my motion stands.
What is your motion, Dr. Johnson?
Let me get it straight. I move that we refer this case to the Attorney General with instruction to immediately investigate with outside investigators for the missing documents, the duplicated counting of ballots, and the missing ballot images listed in the complaint. And I would request a report and report back in 30 days of their findings. And if they are unwilling or unable to conduct an investigation, then I move that we seek outside legal counsel that can conduct the investigation.
Once again, the chair is going to rule that motion out of order. For reasons previously stated, that case has been adjudicated by this board on May the 7th by a vote of 2-1. The Fulton County was sent a letter of reprimand, and an agreement was made to institute a monitor for the upcoming election, which Fulton County has agreed to, and Secretary of State's office has agreed to. Member Lindsay stated in his statement that if it wasn't agreed to, then he would come back and may introduce a motion to further it. Member Lindsay has not done that, and the other prevailing member of that party has not done it. So in order to reopen a case, it would have to be a member of the prevailing party that reopened the case. And as I said earlier, that can't be done at this point because action has already been taken in that case.
I move to override the motion of the chair, the decision of the chair.
Second.
We have a motion to override the decision of the chair, and we have a second. I do want to caution this board that we are putting this board in legal jeopardy by approving that motion. I want to make sure that the Attorney General is aware of that, and the chair will call for a individual voice vote on that motion. We have a motion and a second. Any discussion? Hearing no discussion, we will go in order of seniority. Member Gazal, how do you vote?
Nay.
Member Johnston, how do you vote?
Aye.
The chairman votes nay. Member Jeffries, how do you vote? Aye. Member King, how do you vote?
Aye.
The motion passes. Once again, I caution this board on their actions. And please make sure that the actual votes are in the record for any future potential litigation. Next item on the agenda is that we did skip an item earlier.
We haven't voted.
Oh, I'm sorry. Would you like to restate your motion?
I move that we refer the case to the Attorney General with the instruction to immediately investigate with outside investigators the 3 items of missing ballot images, duplicated recount votes, and missing documents as listed in the complaint of SEB 2023-025. I also move that the Attorney General seek advice of Conflicts Counsel to determine who should represent the State Election Board in investigating this matter. The Attorney General will report their findings in 30 days to the State Election Board. If they are unable or unwilling to conduct this focused investigation, they shall report to the State Election Board immediately so that we may hire outside legal counsel and investigators to complete the investigation.
Member Johnson has made the motion, which I cannot repeat. Is there a second?
Second.
There's a second. Any discussion? Once again, the chair would strongly advise this board to vote against that. It's in violation of a lot of things. I believe that it potentially puts this board in legal jeopardy. And I will call for a voice vote, named voice vote on that, so it can be part of the record. Any further discussion?
Yes, Mr. Chairman, just for the record, I would like to state that I believe this would, voting in favor, this would be a violation of my oath of office and my oath as an attorney to uphold the laws of the state of Georgia, including, not limited to, Aldridge v. City of Lumber City, decided by the Supreme Court of Georgia in 2001. Thank you.
Any further discussion? All those in favor of, let me see, we will vote in rank order. Member Gazal,
Nay.
Member Johnson,
Aye.
the chair votes nay. Member Jeffries, Member King,
Aye.
motion carries 3-2.
I would like to add to, Mr. Chairman, if we, not to this is after that, but the amount of times I've been told not to do something because we could possibly be sued. I mean, if we were doing a drinking game, we would all be drunk. Like, at this point, it's almost, I feel like we can't, we got to make sure we're not utilizing or not scared to make moves because of the fear of that. Because in some cases, it's just the right thing to do.
I would say that it's the right thing to do to follow the law.